docket today. The first case is Cohen versus Statewide Grievance Committee. Before I begin, I just want to remind everybody that if you are not speaking, it's important that you put your microphones on mute so that we can prevent any background noise from people shuffling papers and that type of thing. If you forget, I will mute you. So always assume you have to unmute yourself before you start speaking. Additionally, because we are doing this remotely, we will have judges raise their hand either physically or using the icon. And then I will call on judges for questions based on the order that I can see the hands being raised. When somebody does raise their hand, if an attorney is speaking, please find a natural but relatively quick time to conclude your thought on your prior statement, and we will move on to the next questioner. If you have a problem with the technology, you can also, if we lose sight of you or something, we will stop the clock. It will not count against anybody, and we will have an opportunity for you to rejoin if there's any technological glitches. Justice Doria is going to be keeping time today, and he will notify you by holding up a sign when you have 5 minutes remaining, 3 minutes remaining, 1 minute remaining, and when your time is up. Is everybody clear on those ground rules that we have to adopt on the fly because of this remote argument? Okay. Having said that, then is the appellant ready?
Yes, Your Honor. Yes, Your Honor.
Thank you. Please state your name for the record and the amount of time that you would like to retain for purposes of rebuttal.
My name is DEBRA COHEN, and I would like to retain 10 minutes for rebuttal.
10 minutes. Thank you very much. Please proceed, Attorney Cohen.
Thank you. If it pleases the court, the findings by the reviewing committee are that the June 24th, 2013 fiduciary account was a false statement in violation of Rule 3.3 sub A1 and dishonest in violation of Rule 8.4 sub 3. The reviewing committee recommended a reprimand and 3 hours of ethics training. That's 1 hour in addition to the amount of ethics training required annually for all attorneys for continuing legal education. However, the defendant admitted to the appellate court at oral argument that the defendant did not make a false or untrue statement at all. The defendant also does not claim that the plaintiff represented a client while serving as trustee in the DeRosa Trust. The defendant also acknowledged that the fiduciary account was not dishonest. The reviewing committee found that the fiduciary account dated June 24th, 2013 was inconsistent with an email the plaintiff sent to the probate clerk in May of 2013. The defendant abandoned this argument in the appellate court and argued that the problem with the fiduciary account dated June 24, 2013 is that it doesn't have an asterisk on it or a schedule attached to it that states that the fiduciary fees would be waived. The problem, according to the defendant, is that someone else, some unknown person, might reach into their own pocket and pay the fiduciary fee to the plaintiff after the plaintiff had waived it, and that the plaintiff would not return it. To this court, the defendant argues that the problem with the fiduciary account dated June 24th, 2013 is context. The defendant repeats the false claim that the fiduciary fees were disallowed or that the plaintiff was not authorized to waive the fiduciary fees on the record. However, the defendant acknowledged to the appellate court at oral argument that the fiduciary fees were not disallowed or not unauthorized.
Counsel, I believe Justice Ecker has a question.
Oh, I'm sorry.
You're muted.
I hit the wrong button. Thank you. So, counsel, with respect to the claim of whether or not the entry item for the fiduciary fee, the $5,000 and change was a false statement. I guess the state or the grievance committee argues that it's what the context matters. My question is, part of the context is the statute requiring the filing of a final account. I would think. I mean, the purpose of the final account, why is it being filed and what's being done with it? My reading of the statute is that the final account is not merely a hypothetical statement of numbers that exist out there in the world, but rather a statement that needs to be true and accurate and complete of the financial condition of the estate, including claims against the estate for which the fiduciary is seeking approval by the court, so that once the court adopts or approves the final account, something's going to happen. Money will be dispersed and so forth. Is that an accurate understanding of the statutory framework that defines the statement under review?
It's a difficult question to answer in that the statute doesn't address the actual procedure, which is following the final account is something called an affidavit of closing. So a final account is actually proposed. It is a proposal that certain things have been done or will be done, and it's asking for permission for those items. The probate court is responsible to review each and every item on the fiduciary account and to authorize, modify, or deny each and every item.
So on the face of the submission under the statute, isn't it accurate to say that when you list I get my credits and debits mixed up, but when you list a fiduciary fee of $5,531.84 on that amended final account at issue, what it's really saying, and this isn't really like, you don't have to reach for implications. What it's really saying is, Judge, please approve the disbursement or credit against the account of that amount of money. Is that accurate? I don't want to force it or be inaccurate, but my understanding of how this system works is that that's what that statement means.
Generally, I would agree, but in my case, I had already told the probate court that I would waive the fiduciary fee. The question was whether or not it was going to be on the record so that the probate court could acknowledge it. And of course, the probate court often will decide that fiduciary fees are not appropriate for some reason. They may deny them entirely, they may reduce them, modify them in some way, which happens all the time as people argue for certain items.
Can I just ask you a final question on that, and then I'll let you go. Have you finished your answer? Because I don't want to cut you off.
No, go ahead.
Okay, and I should know the answer to this one. I don't have it in mind though. Was there a hearing actually held on that final account as submitted, the one that you were found to have violated the ethical rules on? Was there a hearing on that ever?
No, the probate court decided not to hold a hearing on that and to take it on the paper, so to speak.
Okay, so your claim is that at the hearing, it would have become clear that you weren't seeking payment of that amount.
Yes, and that's what I had stated in the email from May of 2013, that I would waive it. The question was how to do it. I was being told one thing by my employer, but getting indications of other things from the probate court, through the letter. Of course, the probate court didn't issue anything specific as to fiduciary fees. There was no order, no instruction to waive it or that it wasn't disallowed. What defendant confuses is the instruction from my former employer that I was to waive it.
Thank you. Justice Keller has a question after she unmutes.
Can you hear me? Good morning. I have a couple of questions. What is a streamlined hearing?
That's what the probate court decided to do. The probate court decided to issue notices of a hearing date, but to excuse people unless someone wanted a hearing. In my case, they didn't do that. They didn't issue a streamlined notice. The probate judge just decided not to hold a hearing and to take it on the papers.
Okay, so was there a risk that someone would have just foisted this off to a streamlined hearing, and who writes the checks?
I do. The fiduciary does.
All right, and you might have been instructed to pay yourself because there wasn't going to be a hearing before the judge, correct? Is that the risk that the defendant complains about, that someone might have paid this without raising any issue?
But the problem with that argument, Your Honor, is that there is a final requirement in any estate of an affidavit of closing, which is also signed under, penalty of false statement. And in that is the follow-up, so that it shows all those final payments going out. An accounting includes things that have been paid and things that will be paid and things that maybe will come in. And so the affidavit of closing is the settlement statement, so to speak, where the fiduciary goes through and says, this was the amount listed as on hand in the final account, and this is what happened to that. Did it go up or did it go down? Now, waiving the fee, the amount to the beneficiary would have gone up. If additional bills came in after the final account was approved by the probate court, then that amount to beneficiary would have gone down.
All right, but my question is, if your accounting had just been streamlined and gone through and they decided not to hold a hearing on your accounting, would some minor probate court clerk have A, approved it, and B, approved your final accounting if it came through showing you had paid yourself the fees? Because it was never going to go before the judge, who's the one who knew and the chief clerk knew that you were supposed to be waiving these fees. Well, in other words, I'm wondering, is there a suggestion here that you were trying to slide by here and get your fees and hope that neither the chief clerk or the judge, was it Judge Keeney, noticed? That seems to be the suggestion from the other side.
Well, I think that is, it's appalling that they think that kind of misconduct is going on in a probate court. The clerk is responsible, the judge is responsible for everything that goes on. A judge has to sign something. If some clerk is signing something, is maybe some kind of a cohort with me or somebody, I mean, I guess that's one thing, but the bottom line
is one of 25 things he has to sign that day. And he just signs it because he trusts his clerks to do their job correctly. I mean, these things happen.
But that assumes, Your Honor, that it was my intention to do something wrong, which was never my intention. There's been no proof that was my intention. My intention was to save my job. And I have never once filed a false affidavit. This isn't like the Rubano case in which Attorney Rubano filed 2 accountings, one for the Department of Social Services and one for everybody else. There was one fiduciary statement going to everybody, and there was one affidavit of closing, and the amount on that affidavit of closing matched exactly the amount of cash that went to the beneficiary. In addition to that, the records, it was a very simple estate. All the estate did, the trust did, was hold a mortgage until the beneficiary showed up, because the property was contaminated and couldn't be mortgaged. So the estate held the mortgage. That was the only income. And it was just waiting for the beneficiary to come forward. She had disappeared because of issues that were going on with the town of Enfield. So the context is a lot of imagination of what could happen if, Your Honor, Justice Keller, it is what if the probate clerk didn't do his or her job, or the probate judge didn't do his or her job. But ultimately, it didn't happen. And it wasn't going to happen. I think that, you know, Your Honor has had me in her court. I'm not a liar. And I do as I say I'm going to do. And I have for more than 25 years.
Counsel, do you have, let me just see if Justice Keller has any follow-up questions before Justice Mullins asks his.
No, I'm fine. Thank you.
Justice Mullins.
Good morning, Counsel. I'm just a little curious about what, in your view, was the evidence surrounding your intent.
My intention was the email that I sent that I intended to.
No, not. Maybe. I mean, if that's what you put into evidence, that's fine. But I'm wondering your understanding of the other side's view of what evidence constituted your intent. Was it really inferences that we can glean from the document, or something more than that?
Well, are you talking, I'm sorry, Your Honor, are you talking about the findings by the reviewing committee?
Yes, your intent to make this false statement.
Well, the findings by the reviewing committee seem to be the fact that I was struggling to understand what the probate court wanted from me. In a typical scenario, the probate court receives the proposed accounting and it makes modifications, it denies things, it accepts certain things, and then you move on, they issue their judgment, and then you correct everything in the affidavit of closing. This was a situation in which, thank you. This was a situation in which the probate court just kept sending it back, not even accepting the document, just sending them back. And I had my employer literally screaming at me to do certain things, but no indication from the probate judge of what they wanted. It turns out they wanted a document that could be approved without any modification. They wanted something that could go through each item and say, this is approved. And then the affidavit of closing just showed the final check out to the beneficiary. But that typically is not the way things are done.
But let me ask you, so that final accounting, that's something you swear to though, right? When you submit that, you swear to its accuracy. Is that right?
Well, there's a statement at the bottom in which you say that you're signing it under penalty of false statement. It's not an evidentiary document. It's not sworn to. It isn't notarized. You know, it is something, and I want to let you know that there is no allegation that any of the information in there was false or untrue. This is a question of the defendant imagining that there could have been wrongdoing, but there hasn't actually been wrongdoing. And in the 80 or something estates that I managed throughout that part of my career, there has never been an allegation that I've done anything wrong.
What exactly makes you say there was no wrongdoing? Is it because the fee was actually owed and you just had to figure out how to waive it properly?
Yes.
Okay.
Yes, Your Honor. Thank you.
Justice Ecker.
I just had a quick follow-up to the line of questions that Justice Keller asked. As I read the statute 45A179, if I'm reading the right statute, there's a requirement, mandatory requirement, that the probate judge give notice and hold a hearing on a final account. Is that correct?
Yes.
Okay. That's the only other question I had. Thank you.
let's see. The principles of statutory interpretation require the court to look at the meaning of what is dishonest when it's used in a similar authority. In this case, I've cited a couple of different questions, and my brief provides rules of professional conduct, practice book section 2-69, and case law that makes clear that dishonest conduct involves actual wrongful acts in the nature of theft, embezzlement of money, the wrongful taking or conversion of money, property, or other things of value. The defendant does not allege that the plaintiff engaged in actual dishonest conduct, such as described in practice book section 2-69 or our case law. The defendant relies on false statements and obfuscation of the facts to persuade this court that plaintiff violated rules 3.3 sub A1 and 8.4 sub 3. But the plaintiff cannot imagine an ethics program that addresses false statements that aren't actually false, or dishonest conduct that exists only in the defendant's imagination but never actually occurred. The plaintiff boasted to the appellate court at oral argument about the gravity of harm that discipline causes to attorneys. So it is really important to get these matters right. And I will hold until rebuttal.
Thank you very much. Attorney Staines.
Thank you. Good morning, and may it please the court. I want to address the statements made by the plaintiff. First of all, that I admitted during the oral argument before the appellate court that she did not make a false statement or that the accounting was not false. That's not true at all. Again, we're talking about the context of it, and whether or not the billing that she did was true or false, that was never decided by any probate court, and I think we're all assuming for purposes of this argument that it is true. She submitted the billing for that time period, and it was immediately not approved. So no one ever looked at it to determine whether it was true or false. But again, for purposes of this hearing and the grievance proceedings, I think everyone assumed it was true. And for purposes of this argument, I'll assume that the statement that she did certain work and billed certain hours, that statement was true. But as Justice Eckert pointed out, it's the context of this statement. The billing, although may be true, she was told on several occasions, do not include it in the itemization under debits. Yes, Justice Eckert.
Unmute.
I guess the question comes down to what the false statement was. And what I hear you saying, I mean, look, maybe she went back on her word. She doesn't say that, but maybe she went back on her word. Maybe she had promised, look, I'm not asking for the money. And then she said, you know what? I'm going to ask for the money. Let's say, let's viewing it at its worst. I mean, it's bizarre to me to think that thought she was going to slip it by when everybody was focused on precisely the issue. Putting that aside, let's just say she just said, she changed her mind would be the nice way to put it, right? She said one thing and then did another. But that's not a false statement. It may be a false claim. Under the Federal False Claims Act, I forget if the state has one, when you submit a claim, it contains an implicit certification that the monies claimed are due and owing. That's a false claim. So if this were a claim, it would be a false claim if the monies weren't due and owing. But this is not a false claims provision. It's a false statement provision. And you're going to need to articulate, for me anyway, exactly what the false statement was. Was the false statement, I am owed this money and I want it paid? Is that it?
There's two components of the two different rule violations. Rule 3.3A1.
That's the one I'm talking about. Okay,
that requires a knowingly false statement to the probate court. And here's something that
And what was it? What was in your own words, what did that statement that she made mean that was false?
that if you look at the accounting that's provided, when you add the amount of assets on hand, and then you look at the amount of debits that she's indicating is appropriate, the amount on hand is $2,204.75. That's not the amount on hand. It's $5,531.84 more. That's the false statement. And she was told, don't put it in there. Do not put it in there. And you got to remember, Your Honor, the appellate court recognized that the plaintiff did not appeal the factual findings of the reviewing committee to the appellate court. And so the appellate court was stuck with the factual findings that the actions by continually putting different numbers in the debit amount to eliminate the amount that she was required to pay back was knowing, deliberate, and contrary to a representation in court, and that it was a knowingly false statement, and it was dishonest. Those were the factual findings by the reviewing committee. So they looked at the situation, and again, it's more than just I filed a statement, because originally one of the arguments that the plaintiff made in the Superior Court was it was a mistake. But again, I'm sorry, yes, Justice Mullins.
I just want to understand your answer to Justice Ecker, because it seems like the false statement is the final addition once you put everything together. But the key is that $5,000 payment, right? Isn't that what we're wondering about? If that's
correct. One of the arguments that the plaintiff made in response to a statement I made in the oral argument, I don't understand why she doesn't understand that the context of a statement is what's important here. A true statement in the wrong context can be false. And she indicated that she was just trying to satisfy the probate court that this is an amount that I earned, even though I'm not allowed to collect it, and I'm just showing it on there because I don't know where to put it. Well, that doesn't make sense. That doesn't make sense. Yes, Attorney Collar, Justice Collar. That doesn't make sense because after she was told, after she lists it as a debit, which reduced the amount on hand for the estate, after she did it several times with several different numbers, she was told, don't include it. Don't put it in there anymore. And my statement before the appellate court was, well, if she was just trying to show, oh, by the way, I did earn some money that I'm not trying to collect, then she could have done it as an asterisk or as an attachment or a supplement to show, but she didn't do that. She put it in the line item that actually mathematically reduced the amount due to the estate so that the amount on hand was only $2,204.
Thank you.
That's the problem. Yes.
Justice Mullins, did you have a follow-up question?
No.
Justice Keller. Unmute. Justice Keller, unmute.
I was asking about the streamlined hearing because I don't have a lot of familiarity with probate courts. I've administered my mother's estate and my father's, and I remember that we would get notices that would say, we're going to do this on such and such a date, but nobody has to come. So my question was, you seem to claim that somehow this might have been paid, this amount of money. And by the way, the amount of money was changed, was it not? Initially, she was asking for more, and then in this June 24/13 accounting, happens to now be the exact same amount that she's supposed to pay the taxes and penalties for, correct? Taxes, interest, and penalties.
She did that throughout the process. Which is
one of the reasons why the reviewing committee didn't find her credible. But how could it have been paid? Could it have just slipped through the cracks somehow by procedures in the probate court where it might never have been raised at an actual hearing where people were present, and it might have just been done almost administratively? Is that what you're saying? Who would have paid it by accident?
I don't know the answer to that, Your Honor.
But you seem to claim that some person might have paid these fees to her.
What I'm claiming is the document that she continues to submit, she did it in the context of having this illustrate and represent the final accounting of the estate with the amount due being $2,204.
Okay.
If at any point throughout this process, any one of those documents was approved, then she could have dispersed in accordance with that, and it would have been appropriate to do so. I don't think it's necessary that it was approved and she actually did it and didn't pay herself and kept the money out. That's not required. It's the fact that she was told repeatedly. First, this started off with she had to file the final account. She filed an account, and then it was determined that she owed the tax liability. So she indicated in an email, well, I can't afford to pay the tax liability. I don't have the money to do that unless I claim an attorney fee for the time that was due. So that starts off the ball rolling. So once that appears in there, she was told, you can't claim an attorney fee. You have to take that out. Now, why wasn't that done the first time? Why wasn't that done one time, file a new report, and it would have been over? But no, she filed another one, had the same number in there. She was told, we can't accept this. You keep including it. Do not include it. We agreed you were going to waive it. Then the number changed so that the tax liability was lowered without the attorney fee. She was told, no, that's not the right number. Put the right number in. So the tax liability on the next one went up, and then the attorney fee went back on using that same number. So it was, and we're stuck with what the reviewing committee found. It was her repeated inability to take it out when she was instructed to do so, and filed this accounting that's not accurate. It's not accurate the way she listed the numbers. Mathematically, it's not accurate.
Could I ask one last question? The procedural history is a little vague to me in both briefs. What was the role of the local grievance committee in this case? How does it work? Does it go from local to statewide, or do some matters get passed to the statewide grievance committee? How did it work?
The root of the grievance itself?
Yeah, the root of the grievance itself.
A grievance is filed against an attorney. In this case, Patricia King filed the grievance.
Right.
And it first goes to a local panel.
Okay.
A local panel is represented by an attorney, and it has a group of attorneys, and they review it and gather information and make a probable cause determination. Okay,
and then it goes to the statewide grievance committee.
Then it goes to the statewide grievance committee to schedule a hearing before a reviewing committee. And that's that 3-panel, 2 attorneys, 1 layperson, and they had a contested hearing before the reviewing committee. Once they issued their decision, she filed a request to review before the whole grievance committee. They upheld the decision of the reviewing committee, and then the appeal to the Superior Court.
Okay.
Justice Eckert.
I don't want to preempt any other justices who haven't asked questions, but I'll go, seeing no other hands raised at the moment. I wanted to ask you about the statutory construction issue, or the rule construction issue under 3.3. First of all, what bothers me about that is that the very first line in the commentary says that the rule governs the conduct of a lawyer representing a client. So the question is, does this rule only relate to lawyers acting as lawyers, representing clients, or is it broader? That's the question. And the appellate court says, well, first of all, it says 1(2)(z) applies, which is an interesting question, given that this isn't a statute, it's a rule we made. But putting that one aside, why wouldn't we look at the commentary, not as definitive, maybe not as co-equal in authority to the text, but in the event of an ambiguity, does this apply to attorneys acting in roles other than as an advocate on behalf of a client? Why wouldn't we look to the commentary to resolve that? That's my first question, and then I want to ask you about the rule of lenity, but why don't you answer that one first?
Sure. So you hit the nail right on the head when you mentioned ambiguity. There is no ambiguity in this section of 3.3A1. So, I think maybe a lot of the comments, and I've dealt with just about every rule and every comment, and I would say 99% of the time, an attorney is representing a client. There's very few situations in the big scheme of things that lawyers are not representing clients, but there's a lot of situations where it does happen. So the
isn't ambiguity at the very least created by the fact that it's under the advocate section as opposed to, I mean, I understand in 8.4, hey, lawyers are held to a higher standard, but this is under the advocate section, and every other portion of 3.3 relates to the lawyer as a lawyer. So why isn't there ambiguity there such that the commentary would make a difference?
Well, here's why. So the first section, excuse me. The first section says very clearly that a lawyer shall not knowingly make a false statement of law or fact to a tribunal. Doesn't mention client at all. Doesn't mention attorney-client relationship. But the second part of 3.3 says, 3.3b says, a lawyer who represents a client. That makes a distinction right in the own section of 3.3. Isn't
that because the further sections relate to something done on behalf of the client statement, correcting the client's
well, that's what all the rules are about, Your Honor. See, I don't think we're looking at, well, did they create a rule to apply in a certain situation? I don't think so. There's nothing in the rules that says these things were designed that in this situation you have to be.
But that's what the commentary tells us. I mean, I don't know why I understand in legislative history, there's separation of powers concerns. We deal with the text. We don't look beneath it. We don't want to act, as unelected representatives interfering with the legislative will. This is a court rule. And yet we can't look at the commentary. That strikes me as unusual or odd. I guess that may be not a question. What about the rule of lenity only applies if it's ambiguous? Would you agree with me that if we found this to be ambiguous, that the rule of lenity would apply?
I mean, ultimately, yeah, you're going to make that determination.
I'm asking you what your position is, what the grievance committee's position is.
No, I
Does
believe
the rule of lenity apply to the interpretation of rules of professional conduct is my question.
Well, I believe in that situation where it's ambiguous, yes, I believe that you would do that and you would apply that to make that determination. But, when you look at the first section of the rules of professional conduct that talk about attorney-client relationships, those based on their face, they say when a lawyer is representing a client, you have to move diligently. When a lawyer is representing a client, you have to communicate with the client. Because the context of all of those rules apply in a situation where a lawyer is representing a client, and they're all grouped together. So I don't think when we're talking about communication or diligence or competence, we're necessarily saying we're only relating it to a situation where you're representing a client. It's just that's the way it goes when you're talking about communication with a client. You would have to be an attorney-client relationship. So I think what really is important here is the fact that Part A says you can't make false statements to a tribunal, and Part B starts off by saying, but when a lawyer is representing a client, and it goes on to have a little more specific with regard to that situation.
Thank you. Justice Eckert, do you have any follow-up questions?
I had one other question. Quick question. If we were to disagree with you, this is a hypothetical. If we were to disagree with you on 3.3, but not on 8.4, what would the result be? Would it be remanded for consideration of the sanction or not?
I don't think that would be necessary because I think if you read the decision, the conduct was generally the same. I wouldn't object because one of the rule violations is being getting rid of, and I think probably it would be appropriate, but I don't think it would change the result.
Thank you. Justice Keller.
You're back on mute.
Does 8.4 necessarily require in its comment or in its text that this be an attorney-client relationship? Because I'm concerned that if you say that these rules of ethics only apply to attorney-client relationships, when I think of the multitude of cases where attorneys are acting as guardian ad litems and fiduciaries appointed by courts in probate, where there's certainly room for mischief. Does 8.4 to be read more broadly so you don't necessarily have to have an attorney-client relationship?
I don't even think you have to read it broadly. I think if you
Okay.
look at the actual section, nowhere in the section does it indicate that it's limited to an attorney-client relationship. And same with the commentary. Again, I think a lot of these commentaries that try to develop these issues that are mentioned in the rules are done in the context that most of the situations that we see involve the situation where the lawyer is representing a client. And you know, that I think the commentary of 3.3 that starts off that way is only in that context.
Are we bound by what the commentary says? We can certainly look at it, but we don't necessarily have to accept it as gospel, do we?
Oh, no. And especially in a situation like we have here, where Rule 3.3a does not mention attorney-client relationship at all, but yet 3.3b does mention it. So I think if you just look at that section, those two sections alone, they could have easily put it in 3.3a as well.
You can proceed.
You know, one of the things that Judge Rubino mentioned that I think is very interesting to remember is that he indicated that if you were to adopt the plaintiff's argument, then it would indicate that a lawyer could make a false statement to a tribunal under one circumstance where he's not representing a client, but he couldn't do it if he was representing a client. And that would absolutely lead to an absurd result. So,
Counsel, I have a question. Have we ever actually defined the parameters about when a judge is acting as a tribunal?
no, there's not too much law on that, but I don't think there was any dispute in this situation that the submitting these final reports, these statements of account to the probate court, for them to act on it in a hearing context, they were acting as a tribunal.
Well, let me ask you in a different context. If an attorney signs a pleading that is false for, I don't know, getting a default motion granted, those are acted on by the clerk of the court. Is the clerk a tribunal in that context?
In my brief, I provided definitions, and the definition for the tribunal was included ancillary steps and procedures that take place. So I believe in that situation, if you file a if you filed a pleading or a document with the court and it was false, it doesn't need to be acted on in order to be false under 3.3. The act of doing it is what's important here. So and that's why I'm saying her accounting didn't have to be approved to be false.
So the tribunal, I'm just going a little bit broader here than the facts of this case. The tribunal includes not only a judge, but those who act on behalf of the judge, a clerk granting a motion. In a civil context, the clerk is authorized by the practice book to grant motions for default. A judge never sees them. Is that clerk acting as a tribunal?
Again, I think the tribunal is the process, the legal authority, the submission. You know, if a lawyer sends a letter to another lawyer, that wouldn't necessarily be in a submission to a tribunal. It's the court. When you send a letter to the court, you've submitted something to a tribunal. If it's part of the process.
Thank you. You can proceed.
I have nothing further. If you have no other questions for me, I think I've indicated everything I wanted to respond to.
I appreciate that. Seeing no other questions, thank you very much, Attorney Staines. Attorney Cohen, you have your 10 minutes. Let before you begin, let me ask you the same question. Could an attorney provide a false statement that is never actually going to be seen by a judge? I gave an example of filing a motion that's never going to be seen by a judge, would be just acted on by a clerk.
I guess it depends on context. If they, as you indicated earlier, whether they have authority to do it or not, if the statute provides them authority, I think there are clerks who could go rogue. I do think that when you're talking about, say, a motion for default, it is going into the file. So it is difficult to say that a judge is not going to see it. If there's letters that are going to the clerk and they're not becoming part of the file, I'm not sure that that is.
Well, let me ask you this. Let me ask you this. There are several committees in the judicial branch, the evidence committee, the rules committee, the appellate rules committee, and they're all comprised of judges. But are they? Could an attorney say something false before a committee of judges who were not adjudicating a case, but the attorney is misrepresenting something to a body of judges who are not adjudicating a particular case, but rely on the truthfulness of the statements made by an attorney?
Well, I think that that would not be a violation of Rule 3.3 because 3.3 requires a false statement to a tribunal or an ancillary proceeding, like a deposition. Committees that are not part of the court process, I don't think would qualify.
Would it, to your knowledge, would a false statement made by an attorney to a committee of judges violate any other rules of professional conduct?
Like 4.1 maybe. I'm not as well versed in the rules, to be honest, as Attorney Staines.
Okay, thank you very much. You can proceed.
One of the things that Attorney Staines argues both to this panel and has argued throughout is this concept of somehow I was not allowed, I was told not to do. And I think this is really indicative of how much his office is punishing me because of my former employer's relationship with Pat King, because I filed a grievance against Pat King. I was not told by the probate court anything. I was trying to figure out what the probate court wanted. And I was being told one thing by my employer. My employer said, remove the entry of fiduciary fees from the accounting. And I did. In the June 1st accounting. That was sent back. It wasn't even accepted with a letter saying, I understand you're going to waive. So this argument that I was not allowed, was not authorized, this is Attorney Staines taking up the cause for which I lost my job with my employer.
Thank you. Justice Keller will unmute and then ask you a question. Unmute.
I'm just concerned that there was a hearing at some point in May before Judge Keeney, where you represented to Judge Keeney that you would be waiving the fee. So I guess the argument is that you made that representation to him and then you filed a document where you purportedly were claiming the fee and didn't put like an asterisk, you know, on such and such a date I indicated to the court that I would waive this fee. Why did that happen? Like, why did you put it in after telling him you were going to waive it?
Because it didn't happen that way. That is another false statement by the disciplinary counsel. That hearing in May, I was represented by counsel. That was on May 14th or 15th, I believe. It wasn't until May 24th where Tom Gaffey told me to send that email to the clerk, and I sent the email to the clerk. Attorney Staines has not.
In that email, didn't you say you would be waiving the fee?
I said I would be waiving the fee.
So twice you indicated that you would waive the fee, and then it shows up in that June 24th statement.
You know, Your Honor, once. there was no discussion about the fee at that May hearing. And the reason that Attorney Staines hasn't included the memorandum from that hearing is because that is exactly the case. It is a false statement that has been perpetuated throughout this proceeding.
Did you put it in your appendix, that recordation of what took place at the hearing?
No, I have the letter from the judge dated June 5th.
Yeah.
In which he said, you indicated you will waive, and that was at that was in the email dated May 24th, 2013.
And not at the hearing?
Not at the hearing. My attorney
just
never
said that there's something reflecting what took place at the hearing that will show that you didn't waive anything. Is that, did you put that in your appendix?
No, Your Honor.
Okay.
And neither did the Office of Disciplinary Counsel, because there was no discussion about that. The Disciplinary Counsel did not look at the probate court file, didn't talk to my attorney, didn't talk to anybody but Paul Knierim, who wanted me fired. And it is just a false claim that keeps being made. And ultimately, the issue was how to get the waiver the way the probate court wanted it. My employer told me, don't put it in the accounting. So I didn't put it in the June accounting. The June accounting was sent back to me. It wasn't even accepted. So in my mind, and this is the mistake that I have referred to, my mind, I thought the court wanted me to waive it on the record and to be able to put it in a decree that it was waived. That was my mistake, because apparently that was not what the probate court wanted. But it took another accounting for me to figure out what they wanted, because the probate judge, Judge Keeney, wanted a document where he didn't have to modify or deny any items. He wanted something that he could just approve. So again, there was nothing except for my employer telling me to waive. The probate court did not say anything about, you can't collect this, you can't put it in an accounting, you can't waive it on the record. There was nothing at all. And ultimately, trying to highlight the amount just to make the process easier by reducing a fee that I already said I would waive and had every intention of waiving, and did in fact waive 2 years before the grievance was filed. 2 years before the grievance was filed. This is all about imagination. This is all about the disciplinary counsel trying to punish me. There was no contempt filed in the probate court. There was no orders that I had done something wrong. And yet 2 years later, after the grievance panel dismissed claims of violations of 8.43 and 3.3A1, Suzanne Sutton put additional allegations of misconduct before the reviewing committee, absolutely avoiding another review by the grievance panel. So basically, Attorney King filed a grievance. All of the claims except for 1.7 were dismissed, including 3.3 and 8.4 were dismissed. So the grievance committee took a second bite at the apple, threw those back in as additional allegations of misconduct that went directly to their friends on the reviewing committee. And it's just a lovely system where attorneys that the grievance system finds as inconsequential can be mistreated. Yes, Your Honor.
Counsel, excuse me, I know your time is running out. Thank you, Justice McDonald. Just say that again. There was initially, I know the 1.7 was thrown out, but there were the charges under 3.3 and 8.4 initially were dismissed?
The Attorney King's grievance complaint listed about 10 violations, including 3.3A1 and 8.43. The reviewing panel, the grievance panel, threw all of them out except 1.7. The only only violation that went forward was 1.7. So what Attorney Sutton did, Suzanne Sutton did, was she re-alleged the violations of 3.3 and 8.4. She bypassed the grievance panel and went directly to hearing, reinstating those grievances. Now, the reviewing panel threw out 1.7 and went forward on the second allegations of 3.3 and 8.4. So, Attorney...
Okay, I got it. Thank you.
Thank you very much, Attorney Cohen. And I appreciate both counsel arguing remotely. It's a difficult format if you're not used to it, but it's important for the court. We appreciate your participating on this platform. The court will stand in recess until our 11 o'clock case. Thank you.
Thank you.
Thank you.